Hello, everyone. I'm Michele Shuster, a managing partner at McMurray and Shuster, and I have with me one of my law partners, Chris Wager, and we're very excited to go over all of the developments that happened on Friday. I'm crazy, right?
Nothing like last minute.
I planned to be out of town on Friday, so I should have known that that it would turn out like
Well, it's
this.
perfect. I think the fact that you were going out of town forced that to happen.
I'm pretty certain it did. Yeah, we'll just take credit for the whole thing then, okay? Anyway, so first of all, I want to tell you that we are recording this and it will be available on our website in a couple of days. So if you want to watch it again or share it, you can go to the website and get that. Also, while we are attorneys and we are going to be talking about a lot of legal developments today and their implications for those of you out there, we are not providing legal advice. If you would like legal advice, definitely reach out to us and we'd be happy to work with you on that. Also, I think I just have to say, when we named this, we said it's the end of the world. And then we put it, or is it? And so we did hedge it a little bit, but I think it ended up being a little bit kind of prolific there.
Yeah, and as we'll go into it, it's funny that for all these pronouncements, things are still up in the air. So if you want certainty in the TCPA, it's not easy to get.
Yeah, that's right. That's right. So I just want to start with reading the conclusion of what we're here to talk about primarily, as well as its implications. But obviously, most of you have heard, and if you're on this webinar, you heard in the disclosure of what we'd be talking about, that the 11th Circuit ruled on the Insurance Marketing Coalition, or IMC's, petition regarding the one-to-one and logically and topically related rule that the FCC had passed back in, gosh, it was December of 2023, and then revised slightly a few months later. But as we all know, what that rule did was it required the elements of prior express written consent, the type of consent you need to make marketing calls using certain regulated technology, like an automatic telephone dialing system, an artificial or pre-recorded voice, which we'll just call regulated technology, that you have this additional prior express written consent that was to include a one-to-one consent, meaning only one consumer to consumer could only consent to one seller at a time. And then also the consent that was provided needed to be logically and topically associated with whatever form they were providing that on. So generally looking at websites and, would that website put a consumer on notice that they'd be receiving these types of calls because they're logically and topically related. And so the Insurance Marketing Coalition filed an appeal in the wake of this rulemaking to ask the 11th Circuit to invalidate these new rules. And this is what the 11th Circuit concluded. In an attempt to implement the TCPA, the FCC overstepped statutory boundaries. Agencies only have those powers given to them by Congress, and enabling legislation is generally not an open book to which the agency may add pages and change the plot line. But changing the plot line is exactly what the FCC tried to do here. Congress drew a line in the text of the statute between prior express consent and something more burdensome. Rather than respecting that line Congress drew, the FCC stepped right over it. And then they invalidated the FCC's order. So pretty strong language. I think the 11th Circuit was definitely sending a message there that the FCC had exceeded the scope of its authority. And so what we want to talk about now is, what does this all mean? And I guess we should probably mention that even before the 11th Circuit issued this decision in the IMC appeal, the FCC had stayed the implementation of that rule. So there's one-to-one consent, logically and topically related revisions. And so I suspect they saw that the FCC, or that the 11th Circuit was probably going to rule in a specific direction, or at least if there was even a chance, they wanted to delay implementation. So anyway,
I think the state beat the decision by about 10 minutes.
It did. I think we were just getting ready to hit send on emails about the stay, and then the 11th Circuit's decision came out shortly thereafter. And so, Chris, you want to start running us through some of the things that have happened as a result of that?
Yeah, I would be happy to. Kind of the big question that we're getting is, hey, are we back to kind of business as usual, like this never happened? And I think the answer to that question is both yes and no. So when you look at, I believe, the purely legal standards that are applicable to consent and other issues when it comes to dialing under the TCPA, the statutory and regulatory language is being reverted to what it was before. But the but there is that, because of the whole process that the FCC has put everybody through, I see that there is going to be an enhanced scrutiny. Before even the FCC proposed any of these rules, there have been topics about kind of consent, what is clear and conspicuous, what's readily ascertainable for a consumer. All those types of questions are things that we address with our clients, and quite frankly, the plaintiffs bar, and in our dealings, we speak with the prolific plaintiffs attorney quite frequently about the cases that we have going on. And none of this was lost on them. And I think what has happened is some of these issues that were kind of brewing in the background and maybe weren't extensively litigated before all this happened. I think with the anticipation of one-to-one coming up, the plaintiffs bar and even regulators were really gearing up to address some of these questions. And while at the end of the day, clearly the FCC decision is beneficial, from the industry standpoint in terms of this kind of bright line that the FCC drew is no longer taking effect. I think the attention that this has brought, and quite frankly, the scrutiny, is something where thematically the issues that are addressed, I think we're going to see a lot more litigation on those topics.
Yeah, I couldn't agree more. We're already seeing this in filings that plaintiffs filed well before this rule was set to actually take effect. And, it's the history has a way of repeating itself frequently and over again. And so as we're looking at these issues, the same types of legal questions and the same type of standards are coming back again. And so, it has always been that clear and conspicuous disclosures were required to be given to consumers. Now, the FCC took that a step further, and they had what the court referred to as prior express consent plus, with the plus being the one-to-one and logically and topically related, those plus standards that they didn't have the authority to add. But if you look at consent and how the courts have interpreted it in the past, they use some themes that are really common in consumer protection law. And that is the requirement that disclosures be given in a clear and conspicuous way, and specifically related to do not call and consent to use regulated technology or prior express written consent. They've talked about it being readily apparent to the consumer that they are going to receive telephone calls. So I think it's really well worth our time today to kind of talk about that and revisit some of those themes, because I know overwhelmingly the questions I am getting all through the weekend and today have been, Michele, what does this mean now? You've given us what we needed to do to comply with these one-to-one and logically and topically related rules. Does this mean we just go back to where we were before we made these changes? And, based on what we're seeing as filings in the court from plaintiffs that are already pushing this, and it being something that would be very difficult to get resolved before getting into active litigation, there are lots of good reasons to continue to look at your lead forms and understand where the risks are, and then make sure you're making informed decisions about your lead generation processes and those meeting the requirements for the types of calls being made.
Right. And I would say for TCPA compliance, there really are two buckets to think about. I mean, there's more, but two big buckets in terms of litigation, and that is the consent to call using regulated technology. And the other bucket is calling numbers that are on the do not call registry, and which is not prior express written consent. So it's not directly affected by either the one-to-one consent rule, the former one-to-one consent rule, and the 11th Circuit opinion. But so I think each of these need to be looked at separately. But when you think about consent, again, to me, the question is, the court clearly says you can't just create this one-size-fits-all rule, FCC. And the thing that I fall back on, I think, is kind of a powerful example. And I think the IMC did a wonderful job of this when they talked about logically and topically related. And the 11th Circuit actually took a screenshot of their example. And what they did was, they showed two check boxes where it said, bank A can call me about a car loan, check yes or no. Of B, bank A can call me about debt consolidation.
Kind of what it looked like, although you guys won't be able to see it, but these two boxes that Chris is talking about.
And I think the court correctly said, look, in that instance, it's clear to the consumer that they are asking for both things. And to arbitrarily say, oh, one of those things that you're specifically asking for isn't valid, you can't do that as one size fits all. But when we do, stepping back, the general concept of logically and topically related, I think a court still can look either under UDAP, what's kind of an unfair deceptive practice, or under a principle of, what a consumer is reasonably consenting to. So if you have kind of other, maybe extreme practices where, a linked marketing partners list that has, 2,000 unrelated companies that are listed on a web form that is, some sort of incentivized lead, something like that. Because the 11th Circuit said this is done on a kind of a fact by fact, case by case basis. What is valid consent? So that doesn't bless that, there can be no concept of logically and topically anymore. What they're saying is that there's no one size fits all, but it's still something that we have to be mindful of in creating valid consent here.
Yeah, no, absolutely. I mean, I think the one thing that is clear that the court absolutely vacated the requirement for the one-to-one consent as expressed by the FCC in its rulemaking. And they also got rid of the specific aspects of logically and topically related. And as Chris and I were saying, these concepts, they've been around for a while. And so looking at lead forms and the standard that's used is a reasonable consumer, we can all debate what that means, but there is a reasonable consumer out there, average level of education, reading the common understanding of the words, would they understand as a result of what they are completing on any type of form, that they are going to receive phone calls and that they are going to receive phone calls from specific sellers. But on that specific seller note, I thought there was a really interesting part in the order, and they were pointing out a case where an fax prior or consent to send a fax, they had pointed to a case and upheld it as good law still that you could obtain consent for an entity and then its affiliates. And that has been the question. It's been the $1 million question for a lot of companies, especially companies with a lot of affiliates, the larger sellers. How can you get the consent for these affiliates when a consumer would understand that, same name, maybe a different designation by region, or maybe the type of insurance being sold or something like that, that they were an affiliate of this company that they were providing consent to. And I like it that in the IMC opinion, the 11th Circuit pointed to that and the fact that it was still good law. But I'd love to hear kind of your nuances around that and the types of things that we should caution folks about.
Yeah, I think that there are two parts to that. I think one is, and that is consistent with previous guidance from the FTC under the TSR, talking about, kind of consent for one company. If a consumer will reasonably expect that there's kind of a related entity that has similar name and similar branding, that consent or exemption, DNC exemption can carry across. And I think that does make sense. That the case that the FTC did cite, though, those affiliated entities, actually, there were franchise agreements, I think that court said, so that there was a real legal relationship between those parties. So it's not a free for all where, you can just include a classification. You can't just say, roofing companies in general as to be a catch-all. I still think that it does, at the end of the day, the default rule is going to be to identify the seller. And I think a lot of what we dealt with one-to-one consent, the question opened up because it can be hard, right? In the lead generation space, when you're trying to do a matchmaking service, to preemptively identify who it was. So I think that in a lot of areas, there was a movement to say, well, if we can only name one person, to what extent can we, identify the kind of the publisher or the matchmaking service as providing independent service to the consumer, because and that way that would kind of stand in the space of a seller. So that kind of topic has really come forward. But what's important to remember is, so the one-to-one consent, that rule said one-to-one consent for specific sellers, that was clear. But what we have to remember is, when we dial this back to, you know, the default right now is going to be to move it back to what it was in 2012, the definition of prior express written consent. And that definition still does, again, refer to a seller. So again, you know, we're really moving back to identifying, you know, if you are generating leads and potentially calling and doing transfers, the question you have to ask yourself is who is the seller in that instance? You know, and a lot of times the answer to that can be, you know, the ultimate party that the consumer is going to be connected to and for, you know, whose goods or services are being sold.
Yeah, yeah. You know, I've always thought that drafting language for lead forms is as much an art as a science. A lot of science involved, but as much an art too. And so, you know, I think that as we're working on language for consent forms and our focus is not on these hard and fast one-to-one and logically and topically, that we go back and we're looking at, you know, what is clear and conspicuous?
Yeah.
Is the language in this lead form letting the consumer know that submitting this form that they are going to receive telephone calls from specific sellers, specific companies, and then making sure that those are identified. I do like it that there will be a little bit more wiggle room around the use of affiliates. And again, this is going to go back to the art of drafting those and the total content that the consumer is seeing. But I do think, especially for larger sellers, this is gonna that have clearly affiliated, maybe share same name, obviously same industry for a lot of those types of things. I think it gives them a much more defendable position and a much more credible argument that they can't get consent for those. You know, it's interesting. So you mentioned the 2012 order.
Yes.
And what's so interesting about that in this IMC decision that came out is, you know, the 11th Circuit used this concept of prior express consent, which is what the actual statute says, is that you have to have prior express consent to make certain types of telephone calls. And then for this regulated type of technology, the FCC in its 2012 order specified that if you're making marketing calls using those, then you need prior express written consent.
Mm-hmm.
That is not in the statute that provided the authority to the FCC to implement the TCPA regulations. And there's some language in the order that questions whether the FCC even had the authority to make consent requirement be that it was written, which is really interesting. And we haven't gone through and completely dissected what challenging something like that would look like, whether because, you know, this didn't occur during timeframes that were set at the 2012 rulemaking, if that can still happen. But there's some interesting case law out there about companies that weren't in existence at the time of the rulemaking that are currently affected, that didn't have the ability to object, may be able to do that. It's going to be interesting to see whether we have some further challenges to the FCC's rulemaking in this current environment and with this 11th Circuit rulemaking.
And what's interesting about that aspect of it as well is that it was that 2012 order, when we talked about it being seller specific as opposed to just the party that's initiating the call. That seller language comes in from the 2012 prior express written consent definition. That's not in the statutory language. But I think, you know, with all that, and maybe this is kind of good to transition over to the thought about the calling numbers on the DNC registry, is that, you know, kind of going down this path, the kind of the skeleton in the closet, or the kind of the thing lurking in the background, is the fact that there still are restrictions, you know, under the TCPA in calling numbers on the do not call registry. And it was interesting, right? Because during the whole ramp up to the one-to-one consent, in the one-to-one consent order, the FCC was clear saying, look, this order doesn't affect other provisions, which are particularly, you know, the prior express invitation or other exemptions to call DNC registered numbers. But the takeaway from that, though, is that, you know, there is a history, both from regulators, you know, and even some case law, where there have been arguments that these kind of concepts of one-to-one consent, or, you know, really seller specific restrictions, apply to creating do not call registries. So as we were kind of working to implement one-to-one, kind of the general advice was to be safe. You know, it's also wise to consider extending these one-to-one principles to creating a DNC exemption. And I think that kind of lurking in the background is that, and unlike the prior express written consent, where the 11th Circuit said, look, FCC, there was a specific prior express consent standard that you were supposed to implement. The statute, on the other hand, with respect to DNC, gives much broader latitude to the FCC in order to set up the registry and the regulations surrounding it, so that there's not a similar kind of angle for addressing the rulemaking that addresses the DNC exemption. So the issue is that even when we're not, when our clients are not using regulated technology, the open-ended question still sticks out. Okay, well, what does all of this mean for calling numbers that are on the DNC registry? And what's interesting about that is that, I mean, I think we remember in the one-to-one consent order, the state attorneys general, what now was it was 20 some state attorneys
I
general.
think it was 25, but it may be 23, but we'll just say 24 to hedge.
Right, and it came forward and said, look, the one-to-one already applies under these principles. And again, speaking to both kind of regulators and plaintiffs' attorneys, we understand that, moving forward, they are going to test this notion of DNC exemptions. And, we stand ready. I mean, we're going to take the position, in litigation and defending you in that, that these things are not so limited. But I really do think there is going to be an appetite now for litigation on that front. So I think that, we all have to be mindful. Again, the FCC in a way, squeezed out the toothpaste, and it's going to be hard to jam that in because it has, put these types of issues on people's radar. So I think we really do need to be mindful about creating, calling numbers on the DNC registry and how those lead forms tie up and can empower someone to override those DNC registries and call those numbers.
Yeah, and the specific language that Chris is referencing that's in the statute, not in the regulations that the FCC is implementing, but what Congress passed, it talks about the type of consent that's required. It exempts calls that are made pursuant to an established business relationship, which means you've done business with a company within the last 18 months, or an inquiry EDR, which means they've reached out and inquired about your products or services within the last 3 months. So they talk about an EDR, and then also allow calls to be made with the consumers, and this is the exact language: prior express invitation or permission, evidenced by a signed written agreement between the consumer and the seller, which states the consumer agrees to be contacted by this seller and includes a telephone number to which the call may be placed. And so a lot of emphasis lately on those looking to make the consent requirements, especially in DNC, have really emphasized this seller position. And the AGs, in commenting in the prior rulemaking, really stressed that the FCC didn't need to change its do not call regulations because it already requires one-to-one consent because it references this seller. And I know we see plaintiffs that are pushing this theory as well. And so it will be tested.
I mean, it's interesting because that's a standard that's been applicable for since 2003, 2005, about when the DNC was enacted. So this is something
2003,
this is something where, this issue has been present. And honestly, we have not yet seen much litigation on that subject because I think the plaintiffs bar have been more interested historically in, cases where they deny someone have filled out the form or other aspects, what these suits are based on. But I do see an opening, and again, based from direct comments that I've heard, that there is attention now on this subject due to these changes that were being enacted. So I do anticipate there being litigation where it is saying, this seller standard and whether or not these kind of third-party lead forms or lead forms that have extensive marketing partner lists, whether or not that creates that written agreement between the consumer and the seller.
Yeah, I know we've said it a million times. I'm sure you've heard it a million times. The issue that Chris just raised is if the consent language is wrong, then every lead in your database that you have called on is now a violation that is so easy for plaintiff's counsel to prove because they get your calling records and multiply that times whatever the fine is the court's going to or statutory penalty the court's going to place on those calls, and it's easy for plaintiff's counsel to prove those types of things. So let's see, we have a question here. Do you think that the originally planned updates will ultimately be implemented and it's just a matter of time? or that any updates to the TCPA, if implemented at all, might look quite different than what was planned. You want to answer that? Or want me to answer that?
I mean, I think it's gonna be statutory. I mean, at this point, it's gonna have to be up to Congress and. You've got the crystal ball on legislation to the extent anybody does. I mean, what do you,
Yeah, well, I mean, Congress or states, right? So states have their do not call laws and they have their regulated technology laws. So, one avenue is it doesn't matter what, so I'm going to push the FCC aside for right now. I'll come back to that. But, there are a lot of different ways that these could be implemented. We'll have courts that will be interpreting this language. It will continue to happen. We have some examples of prior court opinions that we can talk about a little bit here too, that will help with that clear and conspicuous definition that we've talked about. So it can happen through the courts. States have their requirements for consent for do not call and regulated technology. Those are still in place, so you still have to meet those requirements. And we have seen, especially in the last 5 or 6 years, that in the absence of the federal government taking a lead in changing the laws after things like redefining what an automatic telephone dialing system is, the states are going to do those types of things. So states could do that. And then, of course, we'll continue to have courts that are implementing this. And the FCC, though, for sure, is limited to that language in what Congress passed in the TCPA. And so the court was very specific as to what the consent requirement was. And there weren't these additional pluses that the FCC put on it that they could initiate a rulemaking to go beyond what Congress had allowed them to do. So I think that the FCC is going to look at this. At the same time, almost the same time, the FCC issued a stay about an hour before the 11th Circuit released the decision in IMC, but they had moved to stay the implementation of the regulations for a year. And so I think clearly the FCC was looking at, making some revisions to what they'd done. I think they probably saw the writing on the wall. Maybe the 11th Circuit communicated with them that the opinion would be released, but I think we're going to see the FCC take another stab at this.
And I see also, I mean, the other aspect too is the FTC, where, under the TSR, there's not a private right of action, so we don't see the volume there, but I think the FTC has taken some pretty strong positions in terms of kind of what are unfair and deceptive acts and practices, and they have targeted. So again, while there may not be these broad brushstrokes where it is, specifically creating these bright line rules, I can see, policing this and what they see as maybe more aggressive tactics. I can see the FCC making some examples out of companies as a way to police this as well, short of the one-to-one consent, providing the blanket rules.
Yeah, I mean, the way just going back a little bit, and so the FTC, Lois Breisman is the assistant director of their Consumer Protection Bureau. And in an event that she and I were on stage together, I was interviewing her. Gosh, it's been a couple years ago now, but she said that it didn't really matter what the FCC was doing because the telemarketing sales rule already requires one-to-one consent. Mm-hmm. And so they didn't initiate any type of rulemaking. What the FTC did instead is they have a document, which I think overall is just an incredible document. It's called complying with the telemarketing sale, or guidelines for complying with the telemarketing sales rule. And they updated that shortly after that event to say that if you are using a pre-recorded message to contact consumers, then because the regulation talks about consent for this seller, that needs to be on a one-to-one basis. And so that has not gone away. Right. Having said that, whether that interpretation is reasonable and whether that'll be challenged if the FTC brings an enforcement action, I think, the Congress, when it passed the do not call laws and gave jurisdiction to the FTC and the Federal Trade Commission and the FCC, they said that they were required to coordinate those regulations so that they were consistent. And so, there's so many different scenarios here about how all these different types of things should play out. And really, I think the takeaway we want everybody to take away from this is we need to go back and look at it. You need to get competent legal counsel to look at what your consent strategies are. And then you need to understand the risk of taking different types of avenues for consent and make decisions based on that.
My big takeaway, I feel like what I have told a lot of clients over the weekend was, come Monday, there's no longer this false deadline, it's not 0 to 100, you don't have to flip a switch and do that. But, the things that we've been working on together for the past 4 months, let's step back and again, to take that risk assessment and say, to what extent were some of these topics that we were developing, should these be integrated? Because, at the end of the day, these, still may be some good things, even though there's not going to be the kind of black or white requirement to do so.
Yeah, yeah. Let's see, we've got consent guidance regarding referrals. I think that's kind of an easy one. So I'm assuming what this question is, let's say I've had my windows changed on my house. And I've been talking to my neighbor who says, I love your windows, who did your windows, will you, can you like refer me to them?
Yeah.
And so I now call that window company and I provide them with my neighbor's name and phone number and for them to call on, we heard you were interested in windows, and we're going to leave out any potential for an inquiry EVR here. Okay?
Right. Yeah.
So, but is that going to provide consent for that type of referral?
No.
No, no, just absolutely no. And we get these a lot, and it's the friends and family programs.
Yeah.
That we get a lot of questions on, and there are specific requirements for language still that do apply for obtaining consent. And I do hear of a lot of companies for those types of things. There's not and I don't advise this. This is never my consent or never my legal advice on this, but for do not call, there's no violation until the second call within 1 year. And I do believe that there are some companies out there that maybe play that a little bit.
Right, and there's plenty of ways to contact consumers that don't involve phone calls
calls
or text messages,
That's
email.
There's still snail mail.
Yeah.
Letters.
Is there really?
I mean, there still is. So yeah, there are other ways, but that is a question we get a lot. Okay. So thoughts on potential impacts of the April 2025 FTC tax revocation updates. I haven't really given that a lot of thought, whether this could potentially affect it. Revocation needs to be honored within a reasonable amount of time, not to exceed 10 days. And so I'm assuming that's what they're talking about. The original implementing statute didn't limit it to 10 days. But I guess the question becomes, is it within the FCC's implementation authority to interpret a reasonable amount of time within that 10 days?
Yeah, no, that's interesting, right? Yeah, I mean, I think this is defining the scope of consent. So in one way, it's not functionally changing that revocation rule, but that does raise an interesting question, which I actually haven't thought about before is, right, I mean, in terms of the authority to make that revocation of consent rule, that's a great question. I have to look back and look at that.
I mean, if you would look at the way that the 11th Circuit analyzed what happened here, it was that there were these additional requirements that the FCC put on prior express written consent that weren't contained anywhere in what Congress had authorized them to do. And so, if you look at it, I can see arguments where it says, well, Congress, said that, well, actually that's in the regulations within the reasonable amount of time. So yeah, I don't know. But you know what, we'll reach out to you and follow up on that conversation, but it is an interesting thing. I don't know that there's any appeals out there right now on that.
No.
So, I mean, there'd have to be the right avenue to do that. I think with the implementation of the revocation of consent, though, I do think that most companies aren't having a significant issue with meeting that. It's a lot different than the huge issues that the one-to-one and logically and topically were.
With the exception being that the revocation potentially being, broader, where the revocating kind of one test is matching program, that means that now the person's already, just because you don't want a specific type of campaign update, then, do you have to completely unsubscribe them and put them on your full do not call list is a tough one. And I agree. I think that's definitely something for us to look into, and I'm glad someone's bringing that up. Volunteer adherence to standards that would comply with the rule prevent insulation against possibly more aggressive enforcement action that may be coming.
I mean, it's kind of what we've been talking about. The question becomes, though, it's voluntary adherence to what? Because the adherence to the rules that were invalidated, I think adherence to those specific rules, not what needs to happen, but what I do strongly urge happens with everybody is that they now go back and they look to make sure that they meet the requirements that were in place prior to November or October of 2023, when the FCC initially introduced these rules. And there are some similarities in what was there before with ensuring that the lead forms clearly and conspicuously disclosed what was going to happen as a result of the consumer providing their consent. And, was it readily apparent to that consumer that they would receive telephone calls or text messages as a result of completing those lead forms? Those types of principles are still going to apply. So it's not that it's the exact same thing that was in place with the FCC's rules that were invalidated, but there are some common themes there, and those need to be picked up on. And as we said, plaintiffs' attorneys are already filing lawsuits that are alleging violations based on not doing those things, not being clear and conspicuous, and not being readily apparent to the consumer. And we all know that there are prolific professional plaintiffs that are out there that know how to game these systems. And those are the ones that usually end up being the very painful, difficult ones, because a lot of them are true believers and they don't settle easily. And so something to be concerned about. Yeah, so I think we answered both of those questions. Well, so I think we've gone over it. We are around. Don't hesitate to reach out to us. I'm going to be speaking, I think, on 5 or 6 additional webinars this week. And so I'm sure each one of those will have a different kind of take on it. But, just in closing, it wasn't the end of the world. It is going to be eased up slightly, but just know that there is going to be a stronger focus on this, I think, by the states, by the agencies that are out there. This might trigger the FTC to maybe send a message out there that those FCC rules may not be there, but this is what we believe ours to be. They are known for doing their sweeps and getting attorneys general involved in those sweeps for filing cases in their states at the same time. And I could see that happening. So
while the specific rule is gone, I think the rationale behind it, I think, is as prevalent as it ever was before. So, right, there's not the black and white test, but I think it's wise for everyone to be mindful and step back and say, kind of the concepts here. What are the things that we can do to further kind of the spirit and what's behind those. And I think that will be, to the point about kind of voluntary adherence. I just think that following those practices both help with, a regulator, because regulators, as we all know, if the FTC, they've got their regulatory discretion. So, it's best to kind of mind your P's and Q's for that. And regardless, I just think that the industry moving forward, I think this has been, it's been an interesting process, and I'm sure everybody wasn't happy to gear up so much. And then it was, 5 o'clock Eastern time, on the Friday before implementation, but here we are.
Yeah. So with those words of wisdom, we'll close out our webinar now, and good luck everybody out there navigating these new waters, and we will talk to you soon. Bye.